Welcome to Legal Darshan. In this video, we are going to discuss case number 36 of the AWAR leading case list given by the Supreme Court of India. And this case is the case of Supreme Court Advocate on Records Association and another versus Union of India. Okay, so this case known as SCAORA versus Union of India, famously known as SCAORA versus Union of India 2015, is the case relating to Collegium system and NJAC. Before moving on to this case, I will dig into a little history about this case. So what is happening? I'm opening Article 124 of the Constitution of India for you here. Now, in Article 124, the term that was used for appointment was that President, in consultation with CJI, that President, in consultation with Chief Justice of India, okay, shall always be consulted. Appointed by President. Now the judges are appointed by President, and President, in consultation with Chief Justice of India, shall be appointing the judges of High Court or Supreme Court, because High Court and Supreme Court are constitutional courts, right? So what happens? This is a chain of 4 cases. So we do have first judge's case, we do have second judge's case, third judge's case, and then comes the NJAC, and then finally we have the SCAORA versus Union of India 2015, which we are discussing in today's video. So what happened in the first judge's case? The first judge's case is SP Gupta versus Union of India. In this case, the court is defining whether this consultation, whether if President is consulting the Chief Justice of India for appointment of, High Court judges or Supreme Court judges, is it a binding recommendation or is it a non-binding recommendation? Okay, so here we will draw the nexus between Parliament and executive and legislature, and we will also draw the nexus between Parliament and in consultation of CJI, President and consultation of CJI. Now what is the term here is saying that President consults CJI. Now we are determining the scope, whether this consultation is binding or non-binding. Now when President takes a decision, when President is taking a decision, he is, basically taking a decision on aid and advice of Council of Ministers. Aid and advice of Council of Ministers, right? This is something we read in Constitution of India, that aid and advice of Council of Ministers is needed for President to take any decision or anything. Now, if a President is appointing if a President is appointing any judge of Supreme Court or High Court, President cannot by itself decide that, because aid and advice of Council of Ministers is important. So here we do see executive interference. President being the head of executive and being advised by a committee of executive is basically denoting an executive, interference. Now, here in SP Gupta, the court says that the term consults is not binding. President can consult CJI, but that consultation is not binding. So if CJI chooses a candidate A and President chooses a candidate B, and CJI, tells him that A is more capable or the candidate A is more efficient, it is non-binding on President to accept what the consultation or what the recommendation is made by CJI. So in the first judge's case, we come to know that the consultation of CJI is non-binding. Non-binding consultation of CJI. So it doesn't bind the President, right? Then what happens 10 years down the line, another case happened, which is sharing the same name as present case. So SCAORA versus Union of India 1, we can call it 1 because it is happening in 1990s, early 1990s. So in this case, the Supreme Court is reversing the finding of SP Gupta versus Union of India and is saying that the term consultation is not non-binding or is not discretionary on the President, but rather it is a mandate, because it ensures the independence of judiciary and it ensures that separation of power is being followed, right? So if, for example, if an executive is appointing the judiciary, so there is executive interference being coming into the picture. So therefore, in this case, SCAORA versus Union of India, it is held that, consultation, the word consultation with CJI has a binding nature and President has to, abide by what CJI is saying in that matter, because it ensures independence of judiciary, an independent judiciary. And secondly, it upholds the principle of separation of power, both of which are forming the part of basic structure doctrine. So now in SCAORA versus Union of India 1, which is 1992 judgment, the Supreme Court is for the first time using the term collegium. Okay, it defines that collegium is a set of four senior most judges who will be making recommendations to the president, and then the appointment will happen. Okay, so collegium was first time determined in SCAORA versus Union of India case 1 in 1992. Now in 1998, the third judge's case is coming, which is in presidential reference, the transfer and appointment of judges by collegium system. So in 1993, the 1998, in the third judge's case, the Supreme Court is laying out guidelines for how collegium will work. Okay, so if one judge has to be transferred from one high court to another high court, who are the judges that we will be taking in consideration? We will take in consideration the chief justices of both the high courts, from where the person is being transferred and from to where the person is being transferred. So for example, if a person is being transferred from Delhi to UP, so both the chief justices will form the part of the collegium so as to, facilitate the transfer. All right. Now, these were the ways in which collegium would work. These were the ways in collegium would facilitate the appointment and transfer of judges. All right. So third judge's case is laying down the procedure, laying down how collegium will work, the point system, how you will appoint a judge, how will you give priority and everything. So today only, the Supreme Court, if you are updated, so today only the Supreme Court has released how the appointments have been made in this year. Okay, so collegium, how many appointments has collegium made, how they were made, considering what criteria, what merits, everything is there on Supreme Court websites, along with the assets of the Supreme Court judges that have been published on the website. So you may go to the website and see for yourself that how collegium has appointed judges this year. All right, and now we come back to what happens next. So what is happening in 2015, in 2014, pardon me, in 2014, the 99th amendment comes. The 99th amendment comes, which replaces collegium by National Judicial Appointment Commission. Now the amendment happens because it was a constitutional amendment, it will take effect. So NJAC happens. NJAC is National Judicial Appointment Commission, and it is replacing collegium. So who is sitting in the NJAC? So NJAC is being constituted by I'll just 6 members. Okay, so 6 members are setting up the National Judicial Appointment Commission, and it is composed of number 1, the Chief Justice of India, who will be the chairperson, 2 other senior judges. So in total, 3 judges we have. 1 is CJI, 2 senior judges, and then the Union Minister who is in charge of Law and Justice. So Minister of Law and Justice, Union Minister of Law and Justice will form the part of NJAC. And apart from that, 2 eminent persons. So these 2 eminent persons shall be appointed by a committee. Okay. So 1 is the CJI, 2 are the senior most judges, the judiciary part, 3rd is the Union Minister for Law and Justice, and 2 more members to be appointed, member number 5th and member number 6th, and those 2 eminent members will be appointed by a committee. And who will be in the committee? Will be CJI, Chief Justice of India, will be the Prime Minister, and will be the leader of opposition. So now here we see that, Prime Minister and leader of opposition and CJI, there is an executive interference in the committee as well, which is appointing 2 eminent members. So the executive interference keeps on adding in the National Judicial Appointment Commission. Now this amendment gets challenged in the case of SCAORA versus Union of India, which we are right now discussing, which is right now the discussion. So as you can see, this judgment is running into more than 1,000 pages, and I, of course, it's a lengthy task to do. So here the crux of the judgment goes back into the SCAORA 1992 case, where Supreme Court is upholding the virtue of independent judiciary. Supreme Court is holding the virtue of separation of power, saying that if there is executive interference in the appointment of judges, the credibility might shake. Okay, the independence might shake. That is why, to prevent that, to stop that, NJAC should not be taken into account. So by 4:1 verdict. So what is happening in SCAORA is similar to what happened when collegium was first defined. So on the ground of number 1, on the ground of independent judiciary, because independent judiciary is a basic structure doctrine being decided in Keshan and Bharati. If judiciary is not independent, it cannot be called as unbiased, or it cannot be called as a protector of the rights, right? Judiciary needs to be independent so that rights of every person, right of you, right of me, is safely secured. So for independent judiciary, for judiciary to be independent, it is important that it is only the judicial person, it is only the people with judicial acumen who should sit as the adjudicator of who will be appointed as a high court or a Supreme Court judge. So independent judiciary was emphasized on in this judgment, that in basic structure doctrine, independent judiciary has been, incorporated as a doctrine of independent judiciary is a prime doctrine that we preserve. And then the next one is separation of powers. So India do follow us a structure which is supporting separation of power. So we do have three organs differently: legislature for law making, executive for law implementing, and judiciary for protecting the law. So in order to protect the law, judiciary needs to be independent. The judicial predominance of legal spirit should be there, right? So predominance of legal spirit is one of the principles that AVDIC is also giving. Because when executive interference comes in the account, predominance of legal spirit might shake. So to maintain that, we do need an independent judiciary, and to make sure independent judiciary is there, we do need separation of power, and we need to adhere to it so that judiciary can function independently, and it can, remain in the pose of protector of rights, interpreter of constitution, and the guarantor of rights for people at large. That is why this judgment, it struck down NJAC. It says that NJAC is unconstitutional on the ground of basic structure doctrine, and therefore restores the collegium system back to as a way to appoint judges in High Court and Supreme Court. So this is the journey we have traveled in 4 cases so far to preserve collegium as of now. All right, this is it for today's discussion. I hope SCAORA versus Union of India is clear to you. This is 2015 SCAORA, or we also call it fourth judges case sometimes. I hope you could connect all the dots together, and I hope this video was useful for you. Thank you, everyone. Keep watching. Have a great day.